Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. This is a follow-up to a previous video where I talked about some lawyers who were behaving badly. They'd compared a witness to Charles Manson, they were joking about this, and they did so in view of the jury. The jury complained, and ultimately the court had to declare a mistrial. So because of that, the court was saying, well, there's probably going to be a costs order, and then the lawyers brought an emergency application to have the judge recuse themselves, which didn't amuse the judge at all. So I talked about that, and in that previous video, I predicted that they would probably have to pay a whole bunch of money. Well, now we have the result. This is the follow-up. We have the conclusion to this story, and spoiler alert, they're going to have to pay a whole bunch of money. But let's talk about how they get there, how much money, and why. We're going to go through the decision as well because the court wanted to make very clear that this was not okay. They wanted to express disapproval in the strongest possible language. And they don't pull any punches. The court spit and fire. So we're going to go through this one because I'm glad it's not me. So let's have a look. This is the case of Jessica McGaw and Sobeys Capital Incorporated. And so this is before Justice Mills, and this is the cost endorsement. So the plaintiff claims she was wrongfully terminated by the defendant and seeks significant damages, including aggravated and punitive damages. So this is the original basis for the claim, right? She's saying she was fired, it was improper, and she wants a lot of money, including money to punish wrongdoing, essentially, as opposed to just to compensate for harm. The plaintiff elected to have her trial determined by a jury. On the fifth day of trial, while a material witness for the defense was providing his testimony, counsel for the plaintiff called up on their computers an image of Charles Manson and then huddled together and laughed amongst themselves, mocking the witness. Evidently, they were of the view that the witness bore some resemblance to the notorious cult leader who was convicted and imprisoned for murder and conspiracy to commit murder. This was done within a direct sightline of the jury box. The behavior of counsel was witnessed by a juror who sent a note to me at the first opportunity when the behavior could be reported in a confidential way. The juror indicated he found the behavior to be inappropriate and he wanted it brought to my attention. Good for the juror. No fault with the juror here. This is exactly what they should be doing. It is unknown whether any other juror saw the image or witnessed the behavior of counsel, but they could have. And if one juror saw it, I mean, they're all kind of in the same spot. If one juror saw it, I'm going to bet that multiple jurors saw it. After receiving submissions from counsel for both parties, I concluded there was no appropriate or adequate instruction that could be given to the jury to address the issue of counsel mocking a material witness by likening him to a manipulative serial killer. And I mean, what instruction would you give here? If you call out counsel's behavior as inappropriate, then you're going to be held to task for basically calling out one side's counsel. And if you don't call it out, well, then the jury is now making this connection, which is entirely inappropriate, right? There's no way you'd be able to make this as a submission in court. The conduct was so egregious, it left me with no alternative but to discharge the jury. And when the court starts using language like this, courts usually use very gentle language. They're very soft-spoken. And typically they will engage in what I like to call judicial snark, which is that the court will call something out, but they'll do so in very guarded kinds of phrasings that don't really, that most people would kind of say are a little overly subtle. But that's just how the courts talk. When the courts start saying that something is so egregious, and especially talking about this as the behavior of counsel, the court's mad. This justice is real mad. When the plaintiff summarily rejected the offer to proceed with the trial by judge alone, I declared a mistrial. Now, in fairness, I probably would have rejected that offer too, just because having now infuriated the justice, do you really, and the justice is a judge, it's just different terms here. I know that's going to be a little bit confusing, but it is what it is. Having now infuriated the court, you don't really want the justice to be the one deciding the trial, maybe. And they wanted a jury, right? That's their right. It's their right to have a jury on this. So yeah, they don't have to do that. But, So the court declares a mistrial. Counsel were invited to make written submissions on costs, and they were specifically asked to address Rule 5707 of the Rules of Civil Procedure, the rule which permits costs to be ordered payable personally by counsel. Now, this is a very rare remedy. What this means is that normally costs in an application are paid for by the parties. And that's because typically costs arise because of actions you've taken. You know, we chose to litigate this sub-issue, this application. We won this application or we lost this application, and therefore, therefore costs follow from that. And these are tactical decisions the client would have had some involvement in. But the client should not be on the hook for the bad behavior of lawyers. And sometimes lawyers behave badly. So there's a rule in the Rules of Civil Procedure here that allows for the court to say, no, this is going to get paid, but it's going to get paid by the lawyer, not by the client, by you specifically. So that's what the court was saying. Show me why you shouldn't have to pay this personally. Court goes on to say, in my view, counsel has brought the administration of justice into disrepute. Now, I'm just going to say these are magic words in the sense that these are words that have more significance than you might think, because the rules of professional ethics require that you not bring the administration of justice into disrepute. So quite frankly, this filing should be triggering these lawyers to make a self-report to the Law Society to say, I got a really adverse finding. You guys need to determine if this is an ethical violation. So hopefully they're doing that, because if not, I'm sure somebody else is reporting them. As an officer of the court, it is shocking that counsel would mock a witness in the courtroom, whether the trial is before a jury or a judge sitting alone. I make no finding of professional misconduct because he's not the person to do that, really. That's going to be up to the disciplinary boards. But there was a clear lack of courtesy and respect displayed in the courtroom by counsel, which impacted the fairness of the trial. He's making no findings of professional misconduct, but he's making several findings of fact that would form the basis for a finding of professional misconduct. So, of great concern to me is that counsel failed to acknowledge the potential impact of the behavior on their own client. And, you know, their client is looking for a result in this proceeding, right? Now what they're getting is they're getting this mistrial and the potential of costs, all sorts of things, right? So this actually hurts the client. They also fail to recognize or acknowledge the prejudice it may cause to the defendant. Counsel remained focused on the fact that their mocking of the witness and the image of Charles Manson was not evidence in the trial. Okay, but you still contaminated the jury pool. In the plaintiff's cause submissions, the claim is made that the disclosure was inadvertent, and she heavily disputes whether the conduct is sufficiently egregious to warrant full indemnity costs. Now, I'm just going to note here, this is kind of a legal fiction here, because these are submissions on behalf of the plaintiff, so it's her voice, except this is really on behalf of plaintiff's counsel. And this is a place where there's a bit of a conflict of interest, because plaintiff has every interest at this point that the cost be paid personally by plaintiff's counsel, because then she saves a pile of money and her lawyers pay the money. Whereas plaintiff's counsel would like to see those costs put on their client. That's a conflict, right? That's an issue. If this were me in this seat, I would be hiring my own lawyers to make these submissions to try to avoid the conflict of interest problem here. I'd be talking to the Law Society going, I need some guidance. And, you know, hopefully I'm never in this position, because hopefully I make better choices with my life. So the plaintiff advises she is seeking leave to appeal the declaration of a mistrial, and submits there should be a consideration to not award full or substantial indemnity costs to the defendant. And I'm not sure if I skipped over it. She says she submits that given both parties made submissions against the declaration of a mistrial, it is not clear that the mistrial was, strictly speaking, caused by the conduct of plaintiff's counsel. I mean, neither side wanted a mistrial because they wanted this decided. But the court's not going to have this. The court's not going to be listening to this at all. The court's got some pretty strong feelings about this one, and they're going to come out and say it. The mistrial was due entirely to the outrageous behavior of counsel for the plaintiff. This was not the exercise of poor judgment during the cut and thrust of a hotly contested trial. Sometimes when you're, in the middle of something, you might say something that was regrettable. There have been cases where lawyers have sworn at the other counsel or something like that because they're upset. He's saying it's not that at all, and goes on to say, rather, counsel mocking a witness in direct view of the jury lacks the exercise of any judgment at all. Ouch. The conduct cannot be justified as being the exercise of bold and fearless advocacy in a vigorous defense of their client. The conduct was inexcusable and merits reproof. Counsel were clearly derelict in their duties as officers of the court and have affected the integrity of the administration of justice. Mocking a witness by likening him to a notorious serial killer cannot be tolerated in any respect, including in circumstances of high conflict litigation. I therefore find this is a rare and exceptional circumstance, because that's really what's required. They don't order these kinds of things often, which merits an exercise of my discretion pursuant to Rule 5707 sub 1 sub c, to order the costs thrown away, payable personally by counsel, on a full indemnity basis. So full indemnity means normally when you get costs, you don't get like dollar for dollar costs. If it costs you $50,000 to run a trial and you get costs, you're probably getting like $10,000, like some portion of it. Full indemnity means that you get back dollar for dollar. What was spent, you get back. And what costs thrown away means is the costs that are essentially wasted. Because when you think about a mistrial, some of the work that you put in on a mistrial is going to be reusable. You can use it again for the next trial, but some of it's going to be wasted. As an analogy, let's imagine I build a wooden chair, and partway through the wooden chair building, something happens and it's ruined and I have to start over. Well, the materials that are physically broken and destroyed, those are thrown away costs. But if maybe I can save the chair legs, those wouldn't be thrown away costs. If I bought a particular kind of power tool that I was using to work on that, that wouldn't be a thrown away cost either, because then I can use it for the next chair I make. So that's kind of the distinction on thrown away costs. It's not all costs, but it's it's dollar for dollar what was wasted in this. The two-step analysis which must be undertaken has been satisfied. The misconduct of counsel was serious, inexcusable, and patently outrageous. It has caused costs to be unnecessarily incurred in a retrial. The conduct of counsel compromised the integrity of the judicial process and resulted in a mistrial after 5 days of evidence before a jury. Oof, that's expensive. 5 days of trial is not cheap. The mocking of a witness by counsel cannot be tolerated under any circumstances, and it cannot be justified as being properly undertaken in the particular circumstances of this wrongful dismissal case. Mocking the physical appearance of a witness by counsel can never be excused as being an exercise of resolute advocacy, which is what they tried to argue. They tried to argue that this was something that they were going to make an issue in the trial, which was a bold statement. Even applying the extreme caution principle, an order imposing costs against counsel personally is warranted. The defendant has provided a bill of costs seeking $140,674.88 in costs thrown away because of the mistrial. Litigation lawyers are all about accounting. They will have accounted for that in detail. The vast majority of the costs claimed have indeed been wasted. There are, however, some expenses incurred which will be of use at the retrial, which is now scheduled for October 2024. In particular, the joint document brief, the will say statements, the trial brief, the jury questions, and the legal research will undoubtedly be utilized for the second trial and may be recoverable in that proceeding if the defendant is ultimately the successful party. So he's saying you're going to be able to reuse this, and you can claim these costs at the next trial if you win. And if you don't win, then you get nothing for those. So the disbursements associated with the joint document brief and the brief of authorities are also expenses that may be recovered following the retrial. The counsel fees incurred in the days leading up to the trial in preparation and the time incurred at trial are all costs thrown away. The witness preparation will need to be redone considering the lengthy passage of time until the scheduled retrial. The fees and expenses incurred in attending the trial and compelling the witnesses to attend will need to be incurred again. So, I'm going to skip over this a little bit, but we've got, the bottom line on this is that the court says, considering some of the work product will be of future use at the retrial, I find that a reasonable and proportionate amount to order for costs thrown away because of the mistrial is $100,000 in fees plus HST, which is sales tax, and disbursements of $4,000 inclusive of the tax. This amount is an intuitive estimation of the fees and disbursements incurred wasted due to the conduct of counsel. It recognizes that some fees and disbursements included on the mistrial will be of use at the retrial. These costs are payable forthwith, which means right now, by counsel on a joint and several basis. What does that mean? Well, there's two lawyers on this, and what this means about joint and several basis is that the other side, and this is Sobeys, right? They're a big corporation, but they're definitely going to come after their money here. Each lawyer is on the hook for the full amount. That doesn't mean that that Sobeys can claim double the amount, but it does mean that they can pick whichever one to go after and go after them, and then force the other one to sue in order to recover this. So Sobeys gets to choose how they divide up who they go after. So that could create some interesting tensions between these two lawyers, because if Sobeys goes after one of them, then the other one says, hey, you owe me half. And they might say, I don't owe you half, I owe you a third because your behavior was worse. And then maybe these other two lawyers end up locked in a lawsuit with each other, which would make it hard for them to continue on at that October trial. So that could be fun. So this order is not intended to be financially punitive, but rather compensatory. The defendant is entitled to be compensated for the costs incurred which have been wasted solely due to the conduct of plaintiff's counsel. I adopt the words of Finch, the true penal effect is in the court's disappropriation of the subject conduct rather than in any monetary penalty. So that's part of why the court is chewing them out so thoroughly here. And you might think, okay, well, that's a lot of money, and ouch. And you're not wrong, but the court's also not done, because there's round two. And round two is this. And this is because the plaintiffs brought an urgent motion to have me recused from making any decision on costs related to the mistrial declaration. Contrary to the submission of counsel, the mere fact the motion was scheduled on an urgent basis for hearing does not presumptively determine the motion was actually urgent. Just because you say it's urgent doesn't mean it's urgent. And if you say it's urgent and it's not urgent, the court's going to be upset. After hearing the matter, I concluded the motion was not urgent and that it was brought solely in an effort to engage in reverse judge shopping. And what he means by that is they're not picking the judge, they're picking a judge they don't want, namely this one who's real upset with them. This amounts to reprehensible, scandalous, or outrageous conduct on the part of the plaintiff, which warrants an order of costs on a substantial indemnity basis as a form of chastisement. I therefore ordered costs payable to the defendant on a substantial indemnity basis and invited submissions from counsel on the appropriate quantum. So the defendant seeks costs in the recusal motion in the amount of $17,293.05, being 1.5 times the partial indemnity amount of $11,528.70. The plaintiff submits that this is an unreasonable and beyond that which an unsuccessful party could reasonably expect to pay. Do you think the court's feeling a lot of sympathy for you right now? The plaintiff has not, however, submitted a costs outline demonstrating what she incurred in this motion. Therefore, it is not possible for me to make a comparative analysis to ascertain what she would have reasonably expected to pay in the circumstances. This is like basic requirements. This is something that should have been done. And the court is saying, why didn't you do this? This was obvious. You're making submissions on costs. Why do I not have your submissions on costs? Come on. That was literally what the court asked you to do. The plaintiff submits there was no necessity for the defendant to respond to the recusal motion, as it did not affect the defendant and it had no particular interest in the motion. Come on. You really think the defendant has no interest in whether or not the justice hearing the matter recuses themselves? That's a ridiculous submission, and the court says as much, saying, this submission is without merit. The defendant had significant costs incurred that were thrown away as a result of the mistrial. It had a material interest in the outcome of the recusal motion. Having presided over the trial and having declared the mistrial, I was in the best position to make a fair and just decision regarding the costs thrown away, which again is that plaintiff's counsel pays $100,000 personally. It was entirely reasonable for the defendant to file a responding factum and to oppose the motion. Yeah, they're entitled to say we disagree. Quite appropriately, the defendant did not file an affidavit on the motion as there was no evidence required beyond the transcript of the hearing. The only grounds on which the recusal motion was advanced arose during the mistrial proceeding. The plaintiff failed to order the transcript, relying instead on her memory of what transpired that day. Again, the court is going, really? Did you maybe want a lawyer in this? Like, this is, if you want to rely on what's happening during the court proceeding, order the transcript. This put the defendant to added costs in counsel having to review their notes and in having to obtain an unofficial transcript. The court obtained the official transcript prior to hearing the motion. It confirmed the plaintiff's memory was flawed, and several statements made in her sworn affidavit were proven to be wrong. Now, that's a big deal. So, before you get your client to swear an affidavit about what happened in court, maybe you should have the transcript so that you don't get your client to swear an affidavit as to wrong facts, because that's a thing you don't want your client doing. Considering the factors enumerated in Rule 5701 of the Rules of Civil Procedure, I find a reasonable and proportionate cost order on a substantial indemnity basis is $15,000, plus disbursements as claimed in the amount of $86.78. So, and the court notes that this motion was represented as being urgent and therefore scheduled on an urgent basis. This required counsel for the defendant to respond under very tight timelines, while also being under a court-ordered obligation to prepare and file cost submissions regarding the mistrial. They were already busy with a tight timeline for that, and then you made them do this as well. Advancing a motion on an urgent basis will often result in higher expenses than would ordinarily be the case. Additional resources will often need to be employed, resulting in some unavoidable duplication of effort. So, the court finds that the billing rates charged by counsel are reasonable and notes that they're somewhat excessive in respect to the preparation for the oral hearing and the drafting of the cost submissions. Two counsel appear to have spent an entire day each preparing for oral submissions, which lasted less than 30 minutes, and more than 10 hours of counsel time in preparing the cost submission. Some of the latter time should more properly have been incurred by a lower billing law clerk or junior associate. It is on this basis that I have reduced the amount claimed by the respondent. Therefore, the plaintiff shall forthwith pay $15,086.78 to the defendant in respect to this failed recusal motion. Now, I'm just going to note here, this one does not have the same order that it be payable personally. And so what that means is that it's actually the client who's on the hook for this. So the client has to pay $15,000 for that, which is rough, right? Because if I'm the client, I'm probably not very happy right now. But I mean, that's kind of how litigation goes. I suspect that this is, I would say that this is the end of this matter, but it's not the end, because there's going to be another trial, so there'll be proceedings with that. But I suspect we're also going to see some Law Society disciplinary proceedings around this, particularly given the language the court chose to use about this, noting that this was, egregious, that it was, affected the administration of justice, these kinds of things. So, however bad your day is, be glad you're not these two, because they just got ordered to pay $100,000 personally. Now, the good news is that on their webpage, they brag about having a sports car. They brag about having, a race car. So maybe that race car could be sold. And I guess if they don't pay up the $100,000 right away, then maybe Sobeys could say, hey, you know what? We're going to claim the race car. I don't know who owns the race car technically, so maybe that's doable, maybe it's not, but it'd be funny if Sobeys ended up owning a race car out of this. Anyway, thank you guys for watching. I wanted to share this one with you because we got half the story, and I wanted to make sure you got the other half of the story. Plus, it's spicy. The court was really coming down hard. That's about as strong a language as you're going to see from the court. And I've never had a ruling describe me in those kinds of ways, and I arrange my entire life to make sure that I never do. So thank you guys for watching. I hope you found this to be interesting and educational. Please like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level, the CCFR, Canada's National Firearms Association, the Canadian Shooting Sports Association, and Lembas for the Elf, as well as at the $20 level, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Here's a Coin Legal Witcher, Cameron Johnson, Andrew Elsich, Vicky, and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time.